Hello friends, you are watching Tax Dosti videos. We are in part 5 of our Sindh High Court Section 7E Tax on Deemed Income. Every Pakistani resident and non-resident is asking, is this a valid law? According to October 2022 judgment of Sindh High Court, it's a valid law. In part 5, we are going to see what the judges are going to write about their logic and why they find this a valid law. Every paragraph we are giving a number, so if you have seeing part 5, it means that you have missed introduction in part 1, 2, 3, 4 paragraphs. In paragraph 5, the judge says, we have heard all learned counsel, that is for the parties including learned assistant attorney general. Learned counsels include petitioners for the taxpayers and respondents for FBR and Ministry of Finance, including the Attorney General, and I have pursued the record. Obviously, a lot of case laws and facts must have been submitted by the different advocates. The petitioner before us are resident taxpayers under various categories, and since these petitions are only premised on a legal challenge, independent facts and status of each petitioner need not be discussed, because in this petition they are discussing whether all these taxpayers who have a different profile, some may be business individuals, some may be salaried, some may be pensioners, some may be people who were non-resident in other countries but now are for tax year 2022 resident, for so all their profile don't matter right now. The only thing matter is whether this section is a valid law and should they pay the tax. Their primary challenge is that Section 7E of the ordinance introduced through Finance Act 2022 is ultra vires to the Constitution, meaning that it is beyond the powers of taxation given to the federal government. It is beyond the competence of the federal legislation in terms of entry 50 of the fourth schedule to the Constitution. Secondly, all of these, now the judge is stating the legal question main and breaking it down into different parts of to which they will then answer in the subsequent paragraphs, and you will be seeing this in our subsequent videos. You are watching part 5. It is beyond competence of federal legislation in terms of entry 50 of the fourth schedule of the Constitution. Secondly, notwithstanding the issue regarding competence of the federal legislation, even otherwise, the levy by itself is confiscatory, too much tax, discriminatory, meaning treating same group of people holding property differently, and is an attempt of colorable exercise of power. Colorable exercise of power means that they cannot tax immovable property, the value of immovable property, but they are doing it indirectly. As in pith and substance, meaning the main tax is the levy in question is tax on property and not on its income. So now the judge has formulated the question and its different parts, which in terms of entry 50 cannot be imposed by the federal legislation. This is the entire gist of their case for seeking a declaration that it is ultra vires the Constitution. So all the efforts made by the advocates, by the petitioners so far till October 2022, since this tax was introduced in July 2022, the honorable judges and the judge writing this judgment has summarized of their claims, and the main petition that they're demanding is that this law should be struck off. So this was part 5. See you in part 6, and I hope that you're enjoying the flow of the judgment, how facts or the law is quoted by petitioners, then respondents, then how the judges understand and interpret and construct the law, and then how they reach the conclusion. Thank you.